I'm gonna give it a few minutes, or not a few minutes, a few seconds really, because we have a lot to get through today before I start doing introductions. I can see people joining right now. I'm already seeing a lot of familiar names. So welcome. My name is Naomi Young. I use she, her pronouns. I'm the policy associate at the ERA project at the Center for Gender and Sexuality Law here at Columbia Law School. For those who don't know, we're a law and policy think tank. We develop academically rigorous research, policy papers, expert guidance. Our most recent piece is a Q&A on today's topic on Rahimi and gender-based violence and gun violence. It's included in the CLE materials, so please give it a read and let us know what you think. And I want to introduce our speakers and our topic, but I want to do a little bit of housekeeping. And if folks have questions about this, please use the Q&A function at the bottom, but also use that to submit substantive questions and comments about what we're talking about today. We are offering one CLE credit for, I always forget the full name of this, but the the diversity credit for this program. And so please stay tuned to the CLE credit code later on. And if you are seeking credit, please return the attendance and evaluation form to eraproject@law.columbia.edu within 24 hours after the event. And we'll, I think I could have Sonia put that in the Q&A as well, just so that you have that on hand. And now I'm really, really lucky to introduce our speakers, panelists, Professors Julie Goldscheid and Victoria Nourse, who are two of the country's leading experts on gender equality and gender-based violence in the law. So this is a very unique opportunity that we have to discuss this really important case coming up. And more specifically, Professor Goldscheid, who's actually a professor of mine at CUNY School of Law, where she also served as Senior Associate Dean for Academic Affairs. Her scholarship focuses on gender equality with a particular focus on gender violence and economic equality, just super relevant for our approach to Rahimi today, and on mechanisms of accountability for gender-based violence. And before she joined CUNY School of Law, she was an impact litigator at Legal Momentum. And we're going to talk about more of this today, but her litigation and policy work there included defending the constitutionality of the civil rights remedy in the 1994 Violence Against Women Act, ultimately before the Supreme Court in the United States versus Morrison. And Professor Nourse is the Ralph V. Whitworth Professor in Law at Georgetown Law Center, and one of the nation's leading scholars on statutory interpretation, Congress, and the separation of powers. You should read her book about impeaching Trump. And Professor Nourse has had a distinguished career in government in addition to being a law professor. So in 2015 to 2016, she served as chief counsel to the vice president, obviously now the president of the United States. And prior to that, she served as an appellate lawyer in the Justice Department and special counsel to the Senate Judiciary Committee. She played a key role in the fight for the 1994 Violence Against Women Act. So if you can't tell, we'll definitely be talking about VAWA today. But today's focus is on a case that's up for oral argument in exactly 1 week. So if you're not doing anything tomorrow morning, or not next Monday morning, oral arguments in United States versus Rahimi will be heard. This is a case about gun rights and the Second Amendment, and it asks whether a federal law violates the Second Amendment by temporarily prohibiting people from possessing a gun while under a domestic violence protective order. Last year, the Supreme Court rolled back decades of sex equality progress by overturning Roe versus Wade and threatening many other important gender justice rights in Dobbs versus Jackson Women's Health. But what also happened in that session that has potentially devastating consequences to gender equality was a decision in a case called New York State Rifle Association versus Bruin, in which the court changed the Second Amendment standard to create a much more limited test that requires any gun regulation to adhere to the nation's traditions and history without concern about whether or not the gun regulation serves an important policy interest. So, or compelling policy interest. And so just quickly, my context for caring about this topic and what I see at stake here is before I started here at the ERA project, I was a senior staff attorney at Her Justice. I'm really happy some of my colleagues are here, and I was representing women living in poverty and a variety of legal cases, but including in family offense proceedings, which is what we call them in New York State, where we seek orders of protection as a civil remedy for our clients who would like some form of protection from domestic violence and family violence and intimate partner violence. So the requirement on those orders that the respondent cannot possess a gun, in New York it actually requires them to surrender a gun. That requirement is one of the remedies that actually makes a difference of life or death. But so I can say that you know this federal law question is of extreme importance. But at the same time, I served women living in poverty. Most of them were women of color. So we can't ignore the problems inherent to relying on remedies like these that do center the criminal justice system and police enforcement. So I feel very privileged that I get to talk about this topic from the context of the Equal Rights Amendment, which centers equality, and in our view, what should be an intersectional view of sex equality. And we want to talk about how we can use the ERA to reorient legal systems' responses to gender-based violence. And so we're going to get into more of those questions about the tension between seeking relief for survivors while also considering racial justice. So I've talked a lot and shared what I see as being at stake. So I'm going to turn to our first panelist, Professor Goldscheid, and ask if you can please explain the larger legal context and what's at stake in the United States versus Rahimi.
Thank you so much, Naomi. It's so good to see you. I'm privileged to be a part of this conversation. I thank you and everyone else at the ERA project for organizing this, for bringing attention to this issue, for facilitating this conversation, and I'm looking forward to it. So just to get us started, I'll say a little bit about why this case is important and why this case is important for gender equality. So, of course, on its face, the case is important because of what it means for gun regulation and for what it means about how the court will interpret Bruin, which so many have criticized from many perspectives and have observed that it already has led to a lot of confusion in the lower courts. But it's also important because of what it says and what the court could say about intimate partner violence and gender discrimination. So some may start by asking the question, what does gun regulation have to do with gender equality, gender violence? And of course, the answer is a lot. And as I thought about the issue in preparing for this webinar, I thought that the case really illustrates so much about how gender bias is baked into our culture. You know, the fact that when people talk about gun regulation, they often don't talk about gender. It's not the first thing that will come to mind when people talk about the need to regulate guns and the harms that guns wreak on so many people. So for that reason, I'm particularly excited to be talking about this and glad to be talking about this today. So I'll just lay some of the foundation by talking about the connections between gender and gun violence, and I'll highlight a few of the statistics that are in the question and answer that the ERA project prepared, and I commend that to everyone because it's really a succinct and comprehensive and nuanced distillation of so much of the data, empirical work, and underlying issues that really frame this case. So just to highlight a few points. The gendered impact of gun violence. Well, globally, this says so much about the United States. Nearly 92% of all women who are killed by guns in high-income countries are American women, are from the US. And of course, much, if not most, of that violence is due to intimate partner violence. So let me say a bit of what many, if not most, if not everyone on this call probably knows about the relationship between intimate partner violence and gender. But women, and I'm going to use the term women because most studies track the impact of intimate partner violence in those kind of gendered terms. So with that caveat, please keep that caveat in mind when you hear me use that term. But women experience domestic violence at about twice the rates of men. And the statistics in these numbers have been consistent over decades. About 1 in 4 women will experience some form of intimate partner violence in their lifetime. Studies also show that women, and particularly racial and ethnic minority women, women with disabilities, pregnant women, and LGBTQ plus people are most at risk of intimate partner violence. And when you combine intimate partner violence with guns, it's, as you know, it's a deadly combination. So over half of all intimate partner violence homicides are committed with guns, and the statistics, the data shows that a woman is 5 times more likely to be murdered when her abuser has access to a gun. So the issues are really serious. The studies also show that young women, racial and ethnic minority women, specifically Black and American Indian and Alaska Native women, are particularly at risk of intimate partner violence homicides. Studies show that Black women are more likely to be killed by firearms than other racial and ethnic groups. And when we think about guns and gender, the gendered nature of firearm ownership also plays a role. Men are more likely to own guns. The images of masculinity that are used in gun lobby marketing also reveal the gendered nature of gun ownership. And we only have to think about the most recent mass killing, like most mass killings, most of the people who commit those mass killings have some history of intimate partner violence. And so it was no surprise to hear that one of the theories that investigators are pursuing in this most recent slaughter, really in Maine, is that there might have been some connection with some former girlfriend. So in addition to that, all the data, the history of gender and gender violence shows how gender violence is inextricably linked with sex or gender discrimination. And you'll probably know that historically abuse was legally tolerated, if not explicitly authorized. And we still have some remnants of those laws on the books today. And of course, we see the legacy of that bias in stereotypes and biases that are imposed on survivors of gender violence, of intimate partner violence and sexual violence. And Judge Ho's concurrence in Rahimi in the Fifth Circuit below is just a stark example of those gendered assumptions. He completely erases the importance of civil protective orders, which studies show do help increase safety for survivors. And his concurrence is filled with classic gendered stereotypes about intimate partner violence survivors, that they fabricate claims of abuse, that they fabricate those claims as a tactical advantage or for financial benefit, that claims of domestic violence are somehow not serious, even though he also claims that people who would commit those kind of acts should, of course, be subject to the criminal legal system. He suggests that orders of protection are easy to get. And I'll just want to bookmark at, for maybe more discussion later, that there are some nuances to this, particularly with respect to how orders of protection are issued and used in the criminal legal system. But contrary to his suggestions, studies show that judges, particularly, well, no doubt in criminal court, but particularly in family court, which is where most intimate partner survivors, intimate partner violence survivors go for redress, that judges in that forum are biased against, not in favor of, intimate partner violence petitioners who are survivors. And people who represent survivors in those forums will tell you about all the challenges that survivors face in trying to get orders of protection. That the experience of survivors in seeking particularly civil protection orders is that they're met with the same kind of gender biases that we talk about when we talk about gender bias and gender violence, stereotypes that they shouldn't be believed, that they're making things up, that they're exaggerating, that they're asking for it, that they're conniving and using the system for some personal advantage. So there's a lot of connections here that we can talk more about in this very quick hour. So I'll just close by saying that our current legal frameworks allow these gendered assumptions and gender and race and other related biases to remain invisible. We've seen the impact of this framework in many cases that we'll be talking about this morning. And I'll just end with the idea that the law need not take that approach. Other countries, other legal frameworks, international treaties recognize that gender violence in and of itself is an impermissible form of gender discrimination. So while the law is never enough to eliminate discrimination and bias, this gives us an opportunity to think about how the law could recognize and take more effective steps to remedy gender violence, gender bias, and other forms of bias. So I'll close there for now.
Thank you so much, Julie. And I'm just going to plug in our CLE materials. We have a paper written by Professor Goldscheid called Elusive Equality that gets into more of her descriptions of the treatment of gender-based violence as sex discrimination in the law. And I think, good opportunity to segue and ask the same question of Professor Nourse to please contextualize this case and give us a little more background in our country's treatment of gender-based violence and gun violence in the law.
Well, thank you very much. I want to echo Professor Goldscheid's comments. This is a very important topic, and the ERA Columbia, project is doing an amazing job. So thank you all for inviting me. And, my co-panelist has given you a tremendous background to the data, the prevalence, the modern problems with this and their intersectional qualities. And I concur entirely. Some of that is included in some of the briefs now on the Rahimi case. So if you're looking for more on that, you can look at some of the work done. Go to Westlaw and look at the files. And I also recommend the materials that Naomi has put together for the Columbia ERA project. I want to take this to a different level. I deal with interpretation in my career, and I am a student and a critic of something called originalism. So I'm going to put this, Rahimi, in a larger frame of the theory that is animating the court and what that has to do with women's rights, how Rahimi is an example of this, and it's an example of a history that we don't learn in constitutional law, where gender-based violence is generally not treated very well by this court or even prior courts. And finally, I'll talk a little bit about the ERA and gender violence as well. I testified in the House of Representatives for the ERA, and apparently someone put a mashup on TikTok. So if you really want the gist of that, you can just go to TikTok and look for me. But I'll tell you more about the legal background and why it may be important. So let me start with that fateful day in June or May, I guess it was May, a couple of years ago when Dobbs came down. And my daughter called me and said, "Mommy, can they do that?" Of course, she knows I'm a law professor. And I said, and she works at a neuroscience lab. She's no slouch, but she's not a lawyer. And I said, "Well, unfortunately, yes, Mia, they can't do that." And she said, "Well, what this business, I saw on Saturday Night Live, all that stuff about going back to the 13th century. And I said, "Yeah, I know." I laughed, but I cried. And then I wrote an op-ed in Slate about why I thought even if Saturday Night Live could get originalism, the rest of the world should begin to understand it, which is something that I've been arguing against for years. The core of originalism is that we go back to 1787 with respect to the original Constitution, and then the dates of the amendment. So 1868 for the 14th Amendment, and that sets our constitutional rules. That's also the rule in Rahimi. So that's why I'm going to try to link them. And I'm going to link them in a way that you probably didn't learn in law school. I mean, we tell a sort of valorized story of the 70s and 80s, women won equal rights, and the amazing litigator, Ruth Bader Ginsburg, and other litigators like at Legal Momentum and elsewhere, worked very hard to gain women's equal protection under the 14th Amendment. Here's the problem with that. Justice Scalia once declared that no one thought that women were included in the Equal Protection Clause of the 14th Amendment. He said this openly, bluntly. And historians will say the same thing. In 1868, there was a big fight between feminists and racial justice advocates because this was to end slavery. If that had given women equal rights, well, why did they have to march and starve and chain themselves to the White House to get the Equal Rights Amendment in 1920? And Justice Scalia is the father of originalism. I believe originalism is not an old movement. I've tried to show that it's actually a modern movement, but it is the movement that now has the hold over the court. And under originalism, at least some versions of originalism, women are not included in the 14th Amendment. So all of those rights that were won in the 70s and 80s are potentially up for grabs. Now, I don't think the court will reverse some of them because they're pretty obvious. So if a statute were to say, oh, no women apply, or, exclude women or exclude a person because of gender, they're likely to find that that's not the proper interpretation. And they have done this in one case recently in Bostock, which included sexual orientation in a statute. But when it comes to the Constitution, most of the rights you think you have are now dependent on history. And for most of history, women didn't have rights. So one of the things I said before my ERA testimony to the press was they threw me out there. Some member said, oh, you law professor, you go talk to the press. And they said, well, what's going to happen in the Supreme Court? And this was before Dobbs. And I said, be afraid. And I meant that because as a student of the method, I knew where they were going to go, and they were going to go back in time. All right. So what does this say about Rahimi? So, well, Rahimi is part of a long tradition where people have, as Professor Goldscheid indicated, the court, and in particular the male justices, but also sometimes the female justices have been silent about this, have downgraded and basically cabined the domestic violence protections that states and the federal government have worked very hard to achieve. This begins in the case called United States versus Morrison. Yes, I had something to do with the original Violence Against Women Act, about which there are many myths. But one part of it that was the heart of the act, according to the current president and according to Waugh, was a civil rights remedy. And that remedy would have provided a civil forum, not a criminal forum. We all knew the criminal justice system had failed. A civil forum for individuals to sue the Harvey Weinsteins of the world. But it was much before its time. And so the Supreme Court struck it down in 2000. And Professor Goldscheid made all of the right arguments, but she didn't get all the justices. And they issued an opinion. There's a bit of sketchy ethics behind this. The judges, including the Chief Justice, who wrote the opinion, actually lobbied against the act. He tried to talk to Biden. Biden refused because it was sketchy ethics. And he sent me, a 30-year-old lawyer. So what's in that opinion resonates with me with all their lobbying against it, which is exactly what Professor Goldscheid just said about Rahimi and Judge Ho's opinion, which is to say it is blatantly sexist. It suggests that women lie to gain protective orders and divorces so that they can gain more money because they're greedy. And this is exactly what, for some reason, they kept thinking that the violence against women was about divorce, even though there was a specific language we put in there so it doesn't apply to any divorce. But I think this is what male judges, or some male judges, let me just emphasize some male judges, because Justice Souter wrote the dissent in that case. Some male judges identify with. They feel, I guess, they're going to be taken advantage of on false claims, or they think men are taken advantage of in this way. But the result is they tar women with all sorts of things that we know have been very dangerous stereotypes. Because what happened since 2000? Well, we've seen Me Too. We've seen the Harvey Weinsteins of the world have been ignored both by the criminal and civil system. Now they try to sue them. It's often, he had to be sued as a sex trafficker at some point. It's still very difficult for the average person to sue in these cases. And Rahimi is part of that long history of judges being very skeptical about the existence of domestic violence and sexual assault, refusing to believe survivors, downgrading it as trivial, despite the fact that we now know, and we've known this for a very long time. No one knew this in 1990 when we started the Violence Against Women Act, but people did know. The data has been very resilient about handguns and domestic violence, that if there's a gun in the room, that's the difference between, well, somebody said on the Senate floor, when they passed this particular thing, it was not part of the Violence Against Women Act. It was passed in 1996 as a standalone bill by Senator Lautenberg. The difference between a battered woman and a dead woman is a gun. And that was by a male senator said that. There weren't very few women in the Senate at the time. And that has been borne out over the last 20 years by the data. So in a piece in Ms. Magazine, I said, well, if we go down the road that Judge Ho suggested in Rahimi, and he suggested, well, I'm going to only criminal, there should be no civil protection orders, then women will die. We had criminal protective orders before we ever started down this civil road, and they did nothing because criminal proceedings are difficult to initiate, and they should be because they deprive people of liberty. This is precisely why the civil system was considered a more appropriate venue for the civil rights remedy in VAWA. So just to go back to our theme, in our third point is, why does this matter for the ERA? The ERA is excruciating, and why am I here today? It's excruciatingly important today. And it's not simply about abortion, it's about everything else. The Supreme Court, the federal government apparently cannot pass a civil rights remedy that would actually give robust civil challenges to individuals. They can't cure the protective order problem in the states. They don't have the power to do that under Morrison. So we need it in the text. And why do we need it in the text? Because if it's not in the text, it does not exist. That is Dobbs. That is Scalia's statement about equal protection, even though that's not what the text means. He doesn't think it includes women. So women need to fight to gain it back in the text. And good news is 38 states have ratified it. Rescissions don't count. They didn't count in the 14th Amendment. So hopefully we can move forward on all of these angles. And as I said in my ERA testimony, I truly believe that women of color will be the largest group who are advantaged by this. I think that intersectionality, the new vision of equality that we can bring to bear here is truly will be groundbreaking, not only for relatively privileged white women, but for all women, in terms of all sorts of things like sitting on corporate boards or, a variety of other things, because Congress has the power to legislate under that. And that is crucial moving forward. Without that, we are not going to attain the kind of gender mainstreaming that is quite clear in other countries and quite well deserved for all American women. And women will die. So with that sad note, I turn this back to Naomi, and we could maybe have some conversations from the audience, and I can answer any of the questions you have about the constitutional aspects of the case and its historical analogs test.
That would be great. I have a couple more questions that are pretty meaty, but we'll try and keep it. Well, you know what? We might, just have time for one, and then we'll do audience questions and try and squeeze in two. That was an incredibly sad history. We all know that it exists. I think I'm speaking for everybody. I thank you both for spending your entire careers working in a very discouraging field. But I do think that, the theme talking about the ERA gives us an opportunity to actually be a bit hopeful. So with this question, I'm just going to ask that you both sort of visualize an alternate trajectory for our history, and what would Rahimi in the Supreme Court look like differently if we had an ERA in the Constitution? What would some of these other cases you've mentioned, how would they have turned out a little bit differently? What would a right to live free from gender-based violence look like? And I'll ask Professor Goldscheid to go first again.
Sure. Well, that's a great question because, as you know, I often ask my students to imagine alternative legal frameworks that are more fair and more just than the ones we have now. So, so I love this question. So for starters, as Professor Nourse said, an ERA would codify, would bring the issue of sex or gender, of course, depending on how it's framed. I'll use the term gender, into the Constitution, and would provide a basis for perhaps requiring an analysis of gender when laws are challenged, laws like the law at issue in the Rahimi case. So in that sense, one thing it would do it would elevate gender discrimination to be on par with other forms of discrimination recognized by the Constitution. Now, I think we have to acknowledge that this Supreme Court and previous Supreme Courts don't have a great track record in terms of how they analyze other forms of discrimination as well. So I think this task requires a broad reimagining of constitutional approaches in order to really reach, or in order to be able to reach constitutional decisions that better address the gender, race, and other forms of structural inequalities that we have in our country. So one thing an ERA ideally could do, I'm going to imagine here, I'm going to, think imaginatively, hopefully, it could open the door to substantive equality analyses that would help claims of both gender and race and other forms of discrimination, because currently the court's jurisprudence on disparate impact, for example, have made many kinds of constitutional claims hard to bring or hard to prevail on. And so it could open the door to a more robust set of cases addressing that type of discrimination, which is so much of the discrimination that we see today. In terms of the Morrison case, it could be really important in reaching a different result. So in Morrison, as Professor Nourse alluded to, part of the court's decision was based on the old public-private divide that has, been so harmful to all sorts of advocacy efforts to shine a spotlight on intimate partner violence and other forms of gender violence. So just to say a little bit about the court's reasoning in Morrison, so when I was working on the Morrison case, people would often say to me, what's the issue? And the issue was something that many people haven't thought about, but lawyers on this call will know that every law has to have a constitutional basis, and the primary constitutional bases that were put forth in support of the civil rights remedy, which was at issue in Morrison, were the Commerce Clause and a part of the 14th Amendment that gives Congress the ability to enact laws to address constitutional violations, that would include gender discrimination. And I just have to credit Professor Nourse and the others who created the record that was really the basis for the reasoning in Morrison. I was not personally involved in any of that, but relied on it extensively. And it was nothing short of prescient in laying a foundation for how, in my view, the court should have upheld the law. So in brief, when we think about the ERA, we think about this discrimination. I think about when I was litigating the case and people would say to me, well, the constitutional basis for a civil rights remedy for domestic violence, sexual assault, gender violence, that has to be equal protection. And it was one of the arguments, along with the Commerce Clause argument. But what the court ended up reasoning was that Congress couldn't regulate gender violence, domestic violence, sexual assault, because it was private conduct. And that's the public-private divide that we've both talked about now. So we could imagine an ERA empowered to look more broadly at the nuances and the realities of the problem of gender violence. And it could generate a new jurisprudence that looked more broadly at the kind of remedies that were needed, the kinds of remedies that survivors actually need in order to be safe and to address the violence in their lives. So it could be more expansive in that way. And just along those lines, it could look at not only gender, but also race discrimination to address both the gendered impact of guns and gun violence, but also the racist history of gun violence regulation, of gun regulations.
Well, thank you very much for that, Professor Goldscheid. As I run an institute on Congress, I'll just put a plug in for Congress. I mean, I don't have much hope that the court is going to be jolted out of its current historical frame. But if you were actually to put text in, that would create a conflicting right in Rahimi, which would stop them, in my view, to going all the way back to a position when women were not included in the Constitution, if that's their position about the 14th Amendment. And I think could operate, and I would argue if this ever became, real, and that would be a powerful resistor to a lot of other claims. You have the First Amendment in a case called Counterman that was just up there that narrowed a stalking law. Well, and Congress could in fact direct the court to consider certain kinds of things under this authority if they want to, if there is a need. And I think that congressional authority is crucial. Why? Well, what happened after the 14th Amendment was passed? Well, not much. I mean, we still had slavery and virtual slavery and indentured servants and, sending people to prison for life and all these kinds of things. We only got any movement with the 1964 Civil Rights Act, and that's where women were added as a joke, to kill the bill. So sex discrimination was included in there in 1964. And that's what protects most women's jobs, right? That's what most people, they think of, can they fire me because I'm a woman? Well, it's that statute. It's not necessarily the Constitution because it's a private employer. Again, it's not the state. So the Equal Protection Clause only covers the state, as Professor Goldscheid, and state action, if you remember that from your common law classes. So this could allow Congress to enact another piece of legislation akin to and as dramatic as the 1964 Civil Rights Act. And I think that in the current Congress, those of us who care about discrimination would be very cognizant of the intersectional impact of this. And so it could be truly transformative of our thoughts on how we approach this violence, because some of it has to do with framing effects. They never talk about domestic violence as a pattern defense. It's a pattern defense. So if you take one little thing out of a whole pattern, it may seem entirely innocuous. And the court has consistently not only done the private public thing, but they've also minimized by looking at a narrow framing of the actual incident, and assumed that's the entire thing, even though it's a pattern defense. That kind of thing also intersects with all sorts of other problems in particular communities, and gun ownership is one of those. And then that goes all the way up to homicide. And so I see a bright future for a future Congress if young people get out there and vote to fill this gap. I think that's it's a strong form of resistance against the court's decisions, and it's the most effective way to resist them. Not, in my view, I know, the idea that you're going to get term limits and that will do anything, not going to work. The idea that you're going to pack the court, it's just not going to work. FDR tried to pack the court, and he had 67 votes in the Senate. He had 2/3. So, and he still got opposition from his own party. We revere the court too much, in my opinion. But I'm one of 2% of law professors who have ever worked in a legislature. So I'm a bit odd in that respect. But I do hold hope for that. And I do think it's an important message that people need to send to the court that they are wrong. And women are the Achilles heel of originalism. And this is a tremendous moment for people to vote against that theory that we must go back to the past for anyone. right?
Like so many little quotable moments that I'm going to go back to the recording to pull out. Women are the Achilles heel of originalism. Okay, so what I'm going to do is try and tie up the questions I see in the chat together with the question I have burning to the best of my ability. Oh wait, this one's a bit long, but I'm hoping that we've answered some of them already through your amazing comments. I want to touch back and Professor Goldscheid and Professor Nourse both alluded to this, but the racial justice aspect of gun regulation and firearms, and this opportunity to recenter equality in this conversation as opposed to the criminal justice system, which is this current center of how we respond to gender-based violence in this country. There is a question in the Q&A about sort of the standard of review that might be applied under the ERA. And I think just going to connect that in there just by thinking about how this is the way that the Supreme Court currently treats race and gender as though they're entirely separate things. And I think we have an opportunity to think about that differently. I do see, and I'm going to let you both respond to that, but want to make sure I'm not missing anything else here, and want to mention the CLE code for everyone. It's Rahimi. So the name of the case is spelled Rahimi, and it's one word with 117 ERA. So that's Rahimi 117 ERA for the CLE code that you need for your affirmations. So again, just want to talk about how we would reframe and reorient the legal system on this principle of equality. And if you could both just keep it like 3 minutes or so, that would be so great. And I'll put it to Professor Goldscheid first again.
So stop me if I go over 3 minutes, but there's so much to say about this. And I guess one point that I'll make in the reframing is that this is an invitation to shift our thinking about how law responds to discrimination generally and gender violence in particular. And just picking up on what you said, Naomi, it's so true, and it consistently, there are examples of this every day of how the reflexive response of legislators and other policymakers to gender violence is to turn to the criminal legal system. So when we think about, how might Congress use the law to respond to gender violence, I think people instinctively turn to the criminal legal system. And what we know about the criminal legal system is that it doesn't do a good job of preventing gender violence, and it causes so much harm. So I think, this is a moment of opportunity to think about other responses. And there's so much, that's happening in communities as responses, as alternative responses to gender violence. But just as some examples, legislators, Congress could think about laws that address the economic impact of intimate partner violence and sexual assault, that address the need for material resources, social services, childcare, public health approaches, alternative approaches to dispute resolution, like restorative justice and other community-based responses that may not be suitable for every case, but may help many survivors and may do a better job of actually preventing future violence, which after all is the whole goal. So I'll stop there, although there's probably no doubt more to say about that. But I guess it's an invitation to think more broadly about remedy that can be part of a different ordering under an equal rights amendment.
Well, I certainly agree with that. When we started in 1990, we were operating in a world where the criminal justice people would not even arrest someone unless they saw them being physically attacked. So every principle taken to an extreme undoes itself. So to the extent that that states have deployed, because the federal government has a very limited jurisdiction. It's 2% of the prison population. Okay, so it can basically cover interstate crimes, and there are some horrible interstate crimes that the Justice Department can, in fact, prosecute, but it's really in the states. And the states have, unfortunately, resoundingly pushed for criminal law solutions, which historically never worked. I mean, I thought we had built, well, as Justice Souter said, in a mountain of evidence showing that the criminal justice system had never worked to prevent sexual assault. It had never worked to prevent domestic violence. And so it was time. That's why we so prized the civil rights remedy. We thought that was the thing that the feds could do. But I see the standard review question slightly differently. I think those are all, I agree entirely. The standard of review, right now, almost all constitutional law is up for grabs. So if you say standard of review, you might be thinking about things like strict scrutiny. And that has been debated with respect to the ERA for a very long time. I am here to tell you that all of those scrutinies are under attack in every area of constitutional law. There are many of the Republican appointed justices do not believe that the scrutinies are based in history. They believe that they are modern balancing tests. They reject balancing tests because they think they're subject to what they call policy. Now, I don't let my students use the word policy because it's just a synonym for not law. I think it's a very vague term that is not particularly helpful here. So if you're thinking, oh, great, we can have a new standard review, well, I'm interested in that too. We're going to have a big conference down at Georgetown on what's happening in Congress to make the ERA real. They're like maybe, 6-8 votes shy in the Senate from making it real. And we're also going to talk about in the afternoon, we're going to, with the head of the ERA project, the forceful and brilliant Catherine Franke, a professor at Columbia, is going to lead a discussion involving what kind of standard of review that law professors think could be obtained under the new ERA in this new world. It's both a visionary conversation in the same terms that Professor Goldscheid indicated. How do we do this intersectionally? How can we have this encompass larger groups and different forms of today's discrimination? And what we mean for women to be equal in the polity, and no one to be subject to punishment because of their gender, whatever gender they so choose. And as well, we have to face the reality, but there are arguments that can be made once that text is in the Constitution that cannot be made now. And so, and we don't know the answer. We can't be confident of what standard of review, but that's why I testified in front of the House. And I said, well, as strict a scrutiny as possible, but I'm just here to tell you there's been a lot of uncertainty and disruption in the last 3 years, and I'm trying to measure this, but I have never seen a more disruptive era in my life. Now, the Warren Court may have been disruptive too. Maybe, the 30s were disruptive as well, the New Deal Court. I can't prove that, but in my view, all sorts of things you learned in con law are now up for grabs on the court. But that's for Congress to I'm also working with Congress to move in on that. They have to act. They have more power over how the court interprets than they think. So with that, I'll say I don't really know the answer of the strict scrutiny question. But I think that's a good thing because, in fact, you can litigate to shape the meaning of the new text. And there's a lot of legislative history that was created the last time we were up there for the ERA, both on the Senate side by Kathleen Sullivan, former dean at Stanford, me on the House side, that would suggest that it covers a broad variety of things from transgender to gender violence to corporate boards to a variety of things.
That was super helpful from both of you. I'm sorry we didn't get to everyone's questions, but from the questions and comments, I do want to say shout out to state ERAs. In the absence of a federal ERA and with the potential for a New York state ERA as soon as next year, we should all be thinking about how we can sort of use our states as not exactly laboratories because we matter in our states, but ways to do exactly what we've been talking about today and reimagining what responses to gender-based violence should look like. So we are out of time. Please, I did see a comment asking for more information about the Georgetown conference. Please just follow the ERA project, sign up to our mailing list, and believe me, you will not escape our promotion of any of our events. So thank you both, Professor Goldscheid and Professor Nourse, so much for being here. This was a thrill for me. Personally, this is a great way to end October, a great way to to anticipate the arguments on November 7th in United States versus Rahimi. And just an inspiration for all of us. Like you both kept going after Morrison in 2000. We can certainly keep going no matter what happens in Rahimi. So please stay tuned. And thank you both. Any last words of wisdom? Thank you.
Thank you.
Yeah, bravo, Naomi.
Thank you. And thanks everyone for coming. You were amazing to show today. Stay tuned. All right. Have a good one. You two wanna?
All right. Bye-bye.